Gyamfi, good morning.
Good morning, Eugene Osepitu.
I spoke to you yesterday. I've read your article. You are of the view that yes, when it comes to the former MP, he has a cause to answer. But the three other members of parliament, based on the provision of 97(1)(g, is so unclear. And you believe the Supreme Court should help us to interpret that matter. And you said that you will be surprised if Bagwin actually vacates or rules to vacate all the 4 seats. He's done that. Yesterday, I spoke to you after the fact. You said you disagreed with him. Why do you disagree with him, briefly?
Yeah, good morning once again, and good morning to your listeners as well. Yes, I disagree with him on the basis that he had it wrong. He got it wrong. You know, people were using Speaker Michael Kwakye's decision for as a basis, as a guiding principle. But you know, I had a cause to write about what Speaker Michael Kwakye did and why I disagree with Speaker Michael Kwakye. And lawyers will say he arrived at his decision per incuriam, meaning he didn't take cognizance or recognition of certain laws and his appreciation of the entire provision of the Constitution. It doesn't lie in anyone's mouth or anybody or authority's mouth to even interpret any provision of the Constitution. I'm sure that was what Leader Afenyo Markins was trying to draw Speaker's attention to, it is that Speaker sought to interpret the Constitution, which is not, the Speaker is not close with those authorities to interpret the Constitution. That was what Leader Afenyo was trying to draw his attention to. But he vehemently disagreed with what Leader Afenyo was saying. However, that is a fact. The Supreme Court, speaking through several of their judges, have maintained that nobody has the right to interpret the Constitution. In fact, it is even in our Constitution. Article 2.1 states it clear that the exclusive jurisdiction of interpreting the Constitution lies with the Supreme Court. And so he had it wrong. Yes, I have said that for the former MP, because of his situation, he was caught by Article 97(1)(8). But for the 3 members of Parliament, their case is a different one. And so he couldn't have boxed all of them together and ruled that he has declared their seats vacant. I mean, that's you like you rightly said, you read my article yesterday, and I gave an extensive analysis of why I have arrived at that point.
Honorable, yesterday, and I asked your colleague lawyer this. Yesterday, when we played the audio of Speaker Michael Kwakye, he made it seem as if the provision of the party on forfeiture holds a certain significance in coming to a conclusion on such a matter. Interestingly, Bagwin yesterday also referred to the notice of poll. The notice of poll, because yesterday one of the things you were trying to answer in your article is that what determines membership of a party, what grounds constitute forfeiture, and the 2 speakers of parliament are relying on provisions of a party and the EC. Do you think that is where the confusion is coming from?
So on Speaker Okwe's ruling, basing it on the constitution of a political party, respectfully, the venerable Leonard Professor got it wrong, because the Constitution, the 1992 Constitution, is the supreme law of a land, and no other law can be superior than the 1992 Constitution. And so you cannot bring a political party's constitution or rules to usurp or even go beyond the 1992 Constitution. So you stick to what the Constitution states. Now on Speaker Bagben, I also watched all the proceedings. Bagben also said that notices of poll has been given to every constituency. That is a fact. So in law, we have something we call judicial notice. Or you take judicial notice of something. It means that, let's say, the incident is notoriously known. It is notoriously known. It's just like when COVID came, for example, and people were unable to even pay their loans because you can't go to work and earn salaries or earn monies to even pay back your loans. And so you can use that as a basis. Just go to your bankers and tell them, because of COVID, I'm unable to go to the market and get some monies to do the repayment. So give me some time. Because it is notoriously known that COVID, there's a pandemic called COVID, and it is affecting everyone. You don't need to even verify again to know that there's COVID because it is notoriously known. I hope you get my point. Now,
I do cancel.
Yes. So now, because the EC has given notices of pull, and it is the work of the EC to do that, and you see, say, Formina MP, who was initially an independent MP contesting on the ticket of a political party, you need not to even go and verify again because he is already on the notices of pull. So it is notoriously known. So he bringing it in. I don't see anything wrong with it. But the only wrong I see here is his interpretation or his understanding of Article 97 1G. That is my only difficulty.
Okay.
That he bringing in the EC. You know why I disagree with him? Because
yes, I do.
The G said if he leaves the party of which he was a member at the time of his election to Parliament, that is the first leg. It is still another party. The statement wasn't complete. He said to join another political party. Now, of these join another political party, it is a yes and no. Because that is Morrison, the whom
Honorable Asante.
Kwadwo Asante,
yeah,
have leave their political party by virtue of going independent. However, he has not joined any political party. But for Mina, because he has contested on the ticket of a political party, you obviously cannot be the candidate for a political party if you are not a member or if you have not joined them.
So if I get you, Formina or Honorable Esiama wouldn't have been part of this group if he had still gone ahead to contest on the ticket as an independent candidate.
Exactly.
Okay. Now, Honorable, finally, the Supreme Court has other pressing matters before it. We've seen 2 weeks ago the demonstration by the Catholic Bishop Conference, the clergy, led by some of the proponents of the bill, including Honorable Sam George of Ningo Pram, saying that there's been some undue delays when it comes to other critical matters. Optics matter, and in the law, you justices say that justice must not only be done, but must also be seen to be done. Do you think if the Supreme Court, now they are the ones we are waiting on, rules on this matter ahead of some of these critical issues before it, doesn't the optics paint the certain picture where people deem it to be doing the bidding of the government?
Respectfully, I am an officer of the court and I will decline to answer this question.
I respect that decision. Thank you, Honorable Clement Opoku Gyamfi.
My pleasure.
Thank you. Yeah, so David, you laughed there. So I know as